Hi, my name is Mara Hardy. I'm one of the planners of West Slope Startup Week, and I'm here to introduce this session. Just so everyone knows, this is the third week of West Slope Startup Week. It's our second annual, and it's been virtual up to now, and we still have 1 week left next week. We've had over 70 sessions, and we're at over 550 attendees with over 100 presenters. So it's been really awesome, just like so full of amazing content for entrepreneurs and business professionals. And I'll do a couple housekeeping items so that this session is recorded, and the recording will be added into Sketch, the online registration platform, into the description of this session, probably by Monday. So check back and feel free to share that. We hope that all participants, we encourage you all to keep your video on so we keep it interactive, but please remain on mute. And if you have any questions, please pop those into the chat box, and I'll be monitoring that throughout the discussion and can share that with our presenters so we can get your questions answered. So West Slope Startup Week is entirely free for anyone to participate and access this amazing content, and that is because we have great sponsors. Our title sponsor is US Bank. They've been a great partner, and they're doing a workshop series, so make sure to check that out. And then we also, our other sponsors are Greenline Ventures, Mountain Dog Media, Colorado Lending Source, CART, ASAP Accounting, and Scape. So thanks to all of them. You are in the Toolbox track, and you are here for the session, Protecting Your Intellectual Property in an Online Marketplace. And I will just briefly introduce our two presenters and then turn it over to them today. So we have Elizabeth Mano and Sabrina Danielson from Perkins Coie LLP in Denver. And they will be giving you everything you need to know about protecting your IP. And again, if you have any questions, pop those in the chat, and I'll turn it over to Sabrina and Elizabeth.
Thanks, Mara. I'm Elizabeth Mano. I'm a partner at Perkins Coie, and my practice area is IP litigation. So I handle when patents and trademarks, when people companies either get accused of infringement or have other people accusing them of infringement or infringing on their own rights. I help handle the litigation for that. And I'll let my colleague Sabrina introduce herself.
I'm Sabrina Danielson. I'm an associate with Perkins Coie here in Denver, and my practice area is trademarks and copyrights, everything from clearing trademarks to helping you apply for and gain federal and state protection over trademarks and copyrights, and then litigation and enforcing those trademarks if and when you need to enforce against an infringer or you're being sued or alleged to be infringing yourself.
So we're very excited to be here talking to you guys today. We do hope this will be interactive. So if you have questions or comments, if you want to put it in the chat, I think Mara will flag it for us and we can have a discussion. So please feel free to chime in at any point. And we'll also stay afterwards if there's any questions to talk about then. So we'll go ahead and get started. So I'm going to sort of lay sort of the background and hit some of the key concepts, and then Sabrina's going to do a real deep dive into various ways that you can actually protect yourself with the various platforms and websites that you see out there. So just to start, I'm sure I don't have to tell any of you this, but you know the internet is huge. We're talking at least 6 billion web pages as of now, and that's not even including all the individual Facebook, social media, other pages that are out there. So it's a huge platform, obviously. And with the billions and millions of users out there, of course, this is great for brand opportunities for your companies. But on the flip side, there's also a lot of potential for abuse of that. So we're going to talk today a little bit about some of the potential pitfalls that are out there and then how you can protect yourself from them going forward. So just a few types of brand misuse that we see online, and I'm sure you guys have experienced some, or hopefully not all of them, but maybe some of them already. Of course, sale of counterfeit or gray market products is a big problem. Impersonation and phishing, spoof sites. I'm sure you've seen these, where scammers will register a domain that looks almost identical to the actual brand name, and it's almost imperceptible, the difference, and so then consumers can get confused by that and end up in the wrong place. We also see online abuse sort of expand even out of the online world with these 800 number customer service scams. So it's where someone will post a fake support number on social media or on a website, and then the users will actually call that number, potentially give out some of their information or account information, So it sort of even expands beyond just online. Then you have people calling and speaking to people in a way that's fraudulent. So there's a lot of concerns there. In the gaming world, we see a lot of promotion of cheats and hacks for games, which of course is concerning for anyone who's trying to run a gaming platform. Fake product or gift card giveaways. I'm sure I see these, I feel like almost every day. I see someone I know, probably who's very sophisticated a lot of times, posting like they really believe they're gonna get that like $1,000 gift card if they just like repost something. And so that's definitely very prevalent. And then lastly, but definitely not least, is cyber squatting. And that, if you guys aren't familiar with that term, that's where someone will buy up a website domain name that has the brand of another company in it. And then oftentimes what they do is try to basically extort money out of the person whose brand it is to get them to buy the domain back from them. And that's actually illegal. There's federal laws against it, and you can challenge that. But of course, that's a big problem. And the fact that it's illegal doesn't stop people from doing that. So just to walk through sort of a specific example, you guys may have seen something similar to this in your companies already, but you see, sometimes we see a scammer will tweet a link from a Twitter handle that's, again, very close to the actual handle that consumers may not realize is just slightly off. And then when a user clicks on the link, they may be taken to a site that's also identical to the brand's login page. And oftentimes consumers, unfortunately, will end up logging in or trying to log in. And by doing that, they are giving the scammer their user ID and their password. And this is especially a problem for cryptocurrency because once they get that information, you know, they can start draining accounts. So that's just one example of how it might play out all the way to like money actually disappearing from consumers. So now that we've covered sort of a lot of the bad things that can happen, what we want to talk to you about today is really how you can protect yourself. So I'm going to walk through now some just the high level things. And then, like I said, Sabrina will jump in, kind of going a deeper dive for all of these on how you can, what you can do to protect yourself. And like she said at the beginning of this, that's Sabrina does that every day. So she is definitely an expert on that. So as far as just overall strategies, you definitely want to have an IP strategy overall seeking protection for trademark for your key brands. And we say here in relevant jurisdictions, and that's important because trademarks are by country. And so you definitely want to make sure that you are looking at what jurisdictions do you think that you're going to be promoting your product in. You may not need it in every single jurisdiction in the world, but you want to take a close look at that and decide what strategically makes sense for you. You want to secure relevant domain names and social media handles. I'm sure that's obvious to you, but like I said, it can be a real problem to get those back. There's a process to do it and you can get it back, but of course it's better if you just secure those right away and don't have to go through that process at all. And then of course you also want to engage in active monitoring for infringement. And that's actually a really important thing. In many countries, including here in the US, your trademarks are use it or lose it. So if you're not out there policing and monitoring and making sure other people aren't using your mark, that can make it harder for you and you could lose your rights or have them seriously curtailed by that. So you always want to be actively monitoring for infringing activity. That's really an essential piece. If you take one thing away from this, make sure that you're monitoring so that you can keep your trademarks rights out there. And then of course also for consumer protection reasons. So there are, as far as monitoring, we just want to make you aware there are a lot of third-party trademark monitoring services out there, so you don't necessarily have to do this yourself. But there are companies that are out there that will watch trademark applications, that will watch domain registrations to see if there's anything coming up with your brand on there, monitoring website content and social media and apps. There's companies that will do all of these things for you. So you can outsource that if that makes sense for you. There's a lot of people that will do that. But now I'm going to turn it over to Sabrina to talk about, if you want to monitor yourself, some of the things you can do, as well as just general enforcement deep dive on how you can start enforcing your rights in the various platforms out there.
Yeah, so one of the easiest things that you can do to make sure that you're not just obtaining that trademark protection on the first side, but continuing to make sure that you have that strong trademark, that strong protection, and looking out for your own consumers and for your business, is to regularly just run Google searches, any search engine, on yourself. I mean, I'm sure we've all gone out and run Google searches just to see what's out there on our names and everything. It's the same thing with your business and your primary core trademarks and brands. Another thing that you can do is you can set up Google alerts for your core brands, your company names, and then small or slightly different similar words to your trademarks so that you can see what's going on out there with not just your brand, but what's very close to your brand. And then you can also set up alerts with the United States Patent and Trademark Office. And so one thing that you can do is through their tests or their search database, through the Trademark Office's search database, you can set up and see what other company brands are being applied for. If there's words or trademarks that are similar to yours, you can go and search for those on the database, see who's out there, who's using words and marks that are close to yours, and get a feel for kind of that landscape. You can also check and see if any of those similar brands or words or marks have been refused because of your trademark. If you already have a trademark application or registration, you can see exactly how the trademark office is working for you, keeping your trademarks, brand, and wording strong. The other option is to go through a trademark clearinghouse, and they just help keep an eye out and alert you to newly registered domain names and kind of those top level domain names.
I was just going to jump in, Sabrina. I think we have a question.
We do. Yep.
Yeah, I don't know if you want to take this, but the question is, what is the threshold for beginning to start the process of obtaining a legal trademark?
Yeah, absolutely. On the threshold side, I would say as soon as you're ready and locked in to a word or a mark or a brand that you think you're going to start using for your company. So if that's your company name, if that's an actual product name, you've decided on something that you like, it fits and it matches your company. The first thing that you want to do is, well, basically run a Google search on that and see if there's anybody else out there that's already using a mark that's similar to that. Because you want to make sure, just like you want to make sure you're protecting your brand, you want to make sure that you're not accidentally going to step on somebody else's toes. If there's somebody out there who's already using a word or a mark that's similar, you don't want to invest a lot of money in that in case that they do the same thing that you're doing here and then enforce their mark against you. So the first thing is run a search, and you can always call up a trademark attorney as well and ask them to run some clearance searches to make sure that you're in the clear and that you're not going to step on anybody's toes. After you've cleared that mark and you're in good shape on that side, then you would just file an application with the United States Trademark Office. And it's a fairly straightforward application process. You can do that on your own. There's no requirement that you have a lawyer do that for you. But you can file that application with the Trademark Office. And then once that starts, that kind of starts the process for federal protection of your trademark. And the Trademark Office will review your application and then most of the time let you know if there's any issues with it or if they have any questions. There might be some back and forth correspondence that you have with the Trademark Office just to make sure that that application's in good shape. And that's kind of the starting process for protecting your brand. I see another question that just popped up. Search on the USPTO included all states' data too. So no, the search for on the US Trademark Office specifically will only give you results from the federal registration or federal register. So it will not include if there is a trademark or a mark that is, say, only registered in the state of Colorado and not registered at the federal level, it will not give you the information. The US Trademark Office will not give you the Colorado state information. You'll need to either check through all 50 state databases. Some databases are better than others, give you more information on trademarks or trade names than others, or you can contact a trademark lawyer, and there are third-party vendors who can run much faster services and searches for all 50 states at the same time. So moving to general enforcement strategies. So let's say once you actually have your federal trademark registration, you've gone through the application process and you've got that certificate, you're ready to kind of take some steps to start enforcing your trademark out there and make sure that there's no infringers out there who are trying to take advantage of your brand already. So you're running your Google search alerts, you're running your searches through the USPTO database. You have, your website, your domain name searches, and you get an alert, and you have somebody who's infringing. So the first step, kind of once you've identified somebody who's actually using and trading on your brand, is to file a takedown request. There's a couple of different ways that you can do this. One is with the actual platform provider that you find this infringer on. Let's say you find somebody on Facebook using your trademark. You file what's called a takedown request with Facebook. And later on in the slides, we have some links that'll show you where to go and the information that you'll have to provide. But that first step it's fairly cost effective. You can do it on your own. Typically there's no filing fee with the platform, so you don't have to pay Facebook to file a takedown notice. The other option is you can file a takedown request with the website host or the website content host if you find illegal or fraudulent activity using your trademark. So you would basically say, okay, there's this website and they're using my trademark. Who's hosting that website? So you can kind of circumvent that first level of infringement and go right to the source of the website content provider and the website host and ask them to just deactivate the website. You say, this is an illegal and fraudulent website using my trademark. This isn't associated with me. Can you take it down? A lot of times website content hosts or providers will do that if you have your federal registration and you can prove that this isn't an authorized website. Let's say you run across a website and it actually appears legitimate. It's a real business trying to make a go of it, just like you guys are, but they are using a similar trademark. What you can do is you can send them a cease and desist letter if you can actually find real contact information. And so this is much more helpful when you're talking to a real person and not one of these kind of bad actors that's trying to go out and do cyber squatting or buy websites and then sell them back to the legitimate company owners. You're not probably going to be able to find legitimate contact information for those types of people, but for the people who are actually out there, just starting a business, selling their wares and goods and services, who happen to pick a trademark and didn't do a trademark clearance search first, you can generally send them a cease and desist letter, letting them know that you have prior rights in the mark and asking them nicely to stop. A lot of people don't want to get into protracted legal debates and arguments about trademark infringement. And so if they're just a general company, a lot of times they'll stop with a cease and desist letter. The next kind of higher level or next step in this process, say you've filed your takedown requests and didn't get anywhere. Say you sent a cease and desist letter and didn't get anywhere. The next step is you can file what's called a uniform domain name dispute resolution complaint. And there are two different systems that you can do this through, but essentially it is a complaint and that you file with the National Arbitration Forum saying this company or this person has purchased a website and a domain name that is too similar to my registered trademark, and they won't give it back to me. They're either holding themselves out and trying to force me to pay them, or they won't respond, and you want to get that fraudulent website down. You can file this complaint, and it's kind of like mini litigation. It has their own rules, their own case laws, their own information on how to get that domain name back. These are more complicated and they are more expensive. There are filing fees typically around the $2,500 to $3,000 mark to just file the complaint. But with that price tag comes a pretty strong arm. If you win your dispute, your UDRP complaint dispute, you get that website and you get that domain name. So it's transferred to you. The bad actor no longer gets to use that. You get the domain name. So it is quite a powerful tool if you're willing to kind of pay that upfront price tag. And then let's say none of these avenues are working for you. You know, we definitely recommend calling in a trademark enforcement specialist, a trademark lawyer, to help you develop an ongoing maintenance and enforcement program. And they can help you kind of develop this good strategy that both protects and enforces your marks and make sure that you're protecting your own business and your consumers. And I think we have a couple of questions here that might be a good place to take these. First one's on filing fees with the USPTO. Yeah, there are filing fees per class of types of goods and services that you want to apply for. $225 or $275, depending on what exactly you're applying for. So the next kind of part of this is really getting to know the exact information and the takedown procedure for filing these takedowns and kind of that first step. Most platforms, whether you're talking about Google, Facebook, Apple, Alibaba, eBay, these all have their own specific takedown procedures and their policies. They want to make sure that they're not hosting counterfeiters, infringers, and various, you know, bad actors as well. So a lot of them have their own links that you go to, their own forms. They make it very user-friendly to file these takedowns. You are more than likely going to have to provide some sort of evidence that you have trademark protection in the relevant jurisdictions. So for you guys, most of the time it's going to be the US, but you also want to make sure that you're protecting your brand in your supply chain. So if you are manufacturing outside of the US and you're manufacturing in Brazil or China, it's probably a good idea for you to register your trademarks in any country that you're in your supply chain, because those are going to be countries where people know about your brand and may be ripe for counterfeiting. And so the required evidence generally is going to be that registration certificate. If you can point to a US or relevant country registration certificate, that'll be a good base for you to be able to have those takedowns go forward. Some platforms will do the investigation themselves. So you just have to fill out their form, say, here's the URL and here's the bad actor that's infringing my mark. And the platform will take a look at that. They'll decide whether or not infringement is actually happening and then take down infringement or not. Others will simply take the takedown request information and then send you contact information to put you in direct negotiations with that bad actor or that infringer, and you can talk to them directly. And so here are some examples of what these takedown procedures or takedown are going to look like. And so the first one is the apple.com, and it takes you to a form that kind of gives you a very broad overview of trademark infringement, copyright infringement, the information that you're going to need to provide, a link to the actual form that you fill out that you can submit. But one of the best that I think is a really great example of everything that you're going to need is a few slides down on the eBay. Yeah, that first one on eBay, if you wouldn't mind clicking that, Elizabeth, it takes you to the notice of claimed infringement, and
I'll also just jump in real quick and say that we are building a West Slope Startup Week resource library where we can share all these slides and stuff as well. So we can also repost that so people have access to it in these great links.
Perfect.
Can you see it now or no?
No.
Let me try to do this better.
Okay. Because here we go. So this notice of claimed infringement, pretty much almost every platform is going to have something very similar to this. And this is the information that you're going to have to provide. Your information, your title, your company name, your contact information, a declaration that says you truly believe that this is infringing your trademark rights, and that you think that this is unauthorized and you haven't given anybody permission to use your trademark. And then you'll need to provide what you're alleging is actually infringing. So whether that's product names, URLs, a description of the infringing material, where the platform can find that infringing material so that they can run their investigation, and then where you have your registered trademark rights. So this is just a good example of when you find somebody who's infringing you, gather up all of this information and you should be good to go to kind of file that first round of takedown requests.
I'm trying to get us back to where we were.
No, yeah, this is great.
Google,
Yeah, so just a lot of various links to the takedown kind of policies, procedures, forms for these various pretty standard platforms that I think most people and most businesses are using. So the next few slides are all kind of the same. Just giving you an overview of that. You can also run takedown requests on various social medias. So Facebook, Instagram, Pinterest, they all have their own takedown procedures. So if you find infringing users who are kind of impersonating your company or using your trademarks or trying to sell goods that are infringing on your trademarks, you can alert Facebook and Pinterest and Instagram and get those accounts deactivated and those accounts taken down. So many, yes.
And we'll get these slides tomorrow so that we can get them up so you guys can have these. It's a good guide that we have here. Okay.
So that kind of takes us to the end of our overview, and here are really the takeaways for online enforcement. The first is to protect your mark. You need to develop that kind of quiver of arsenals of registrations for your trademarks so that you can go out and enforce them. And once you have your registrations and you have your trademarks and they're ready for enforcement, do set up those alerts so that you can find people who are infringing your marks and using them without your authorization. And then once you find those infringers, take the steps to file infringement claims. Set up an every 3-month just day where you search for infringers and file takedown requests with platforms, website content hosts. Note which ones you need to send cease and desist letters to. Set up that enforcement practice so that you're constantly and actively monitoring and enforcing your brand. And then kind of have your canned template infringement information. So your contact information, your trademark registration numbers, your trademark information, when you started using that trademark. And then you'll need the information and URLs on the claimed infringing content for any trademark takedown request that you're going to file. And I'll let Elizabeth jump in here on the patent enforcement because that's more of her side on the patent side.
Sure. Before I do, I was just going to ask you, can you give an example of like something that you maybe you've seen with a client or something where they didn't bother doing the takedown? They just said, you know what, this is a pain. I don't want to like be monitoring. Like what can happen if you do that?
So what happens when you decide not to take action against infringers. One thing specifically with that infringer, against that specific infringer, they could come back and say, well, you've known about us for a long time, or we've been operating for 2, 3, 5 years and you haven't done anything. So why are you coming after us now? And that's a legitimate argument. If you don't take action against a specific infringer, you can lose the right and ability to take action in the future. So when you find infringers, that's the time that you need to take that first step and file a takedown request, or send a cease and desist letter, or do something that shows that you are actively trying to enforce your trademark. Because if you don't, there is a chance that you won't be able to later on. You lose that right. You've kind of agreed and acquiesced that, well, you're using it, so you can go ahead and use it, and it becomes quasi-authorized because you didn't take any action. The other reason why you want to take kind of swift action when you find infringers is if you don't take action and you're not generally monitoring and keeping your brand as your own brand, you let a lot of other people start using it, and that weakens your trademark. And you can't go out and say, I have a strong trademark, I have a strong brand, and this brand or this word identifies me and only me, because it no longer does. If you let other people and infringers and other companies use similar marks, you can't kind of create that brand consumer awareness where a consumer would say, oh yes, that word identifies your company as the source of a good or service. And so if you can't do that, then you're just weakening your actual brand recognition with consumers.
Thank you. So yeah, just a quick note.
And actually, there's a great question here. If you ignore infringers, can they come after you for infringing their brand? No, yes and no. Probably not. You will probably be able to prove that you have prior rights in the mark, that you've been using it for a certain amount of time. And since they would be considered the junior user, they probably won't be able to jump in front of you on that kind of claim to the trademark brand. But what that does do is, if you don't go after them, you lose your ability then to go after that infringer. And it could also bring you into a very expensive legal battle to prove which one of you has actual rights in the mark. So no, they probably can't claim that they have superseding rights in the mark, but that doesn't stop them from filing a lawsuit against you, and that doesn't stop them from, you having to spend money to defend against that lawsuit or defend your own ability to use your own trademark. So
yeah, from a litigation perspective, that's something someone can file a lawsuit and try to cancel your mark. I mean, that does happen. Obviously, that's rare and it's hard to do, but it can be done. So if you aren't keeping up with what you're supposed to be keeping up on your mark and you've sort of let it go and aren't enforcing, that could eventually be the result. So it's just easier to just stay on top of it and not let that happen, and not give someone that argument or that opening to try to file a lawsuit against you on that. There's another good question on here about website content and copyright infringement. Do you want to address that, Sabrina?
Yeah, let me just read this one real quick. IP includes things. Yes. Yeah, absolutely. So on the copyright infringement side, absolutely, there are mechanisms that are very similar to the trademark takedown requests and notifications, that you just identify that it's a copyright instead. And so if you have someone or an infringer taking, say, paragraphs of written content from your website, or photographs of your products from your website and putting them up on their own, I see this constantly, where product photographs are pulled directly from the legitimate company website and then put up to sell counterfeit goods. You can absolutely file a copyright infringement takedown. Let let the website content host or the platform know that it's a copyright infringement. And in fact, there's an even stronger kind of hand to copyright infringement than to trademark infringement. The Digital Millennial Copyright Act basically says that a website content host, if they are alerted to copyright infringement, where somebody is taking paragraphs of written content or images or photographs or anything that you've created and you're putting on your website, if somebody is taking that, the website content host has to take that down. They have a much more strict duty to remove copyright infringed material. And it's a little bit more of an oomph and packs a bigger punch on the copyright side. So you should absolutely be looking for the stuff and products and information and any medium that you are creating and putting up on your website to have copyright infringement takedowns done.
Yeah, I think all the things you talked about earlier, Sabrina, are applicable, including, you know, trying to reach out individually with like a cease and desist letter first, because I've seen it. This is something, just sort of a cautionary tale, but you got to be careful who you hire to do your marketing, because sometimes marketing people will be like, oh, I found this great website, and they put it on yours, or vice versa. They take it from yours and put it. And so I've had this happen where we sent a letter to somebody and they were like, we're really sorry. We didn't realize that our marketing person hadn't drafted this themselves. They you know, took it off the website and they just immediately took it down. So all the same tools apply for copyright, like Sabrina said. Mm-hmm. And then to segue to the patent slide we have here, just, I mean, patent law can get a lot more complicated and a little bit more difficult, but there are still procedures for patent infringing products. And so each of these marketplaces has a process for that as well. So if you are thinking about getting patents or you have patents and you want to enforce those too, that's definitely an option. It can just be a little harder for obvious reasons. Patents, you have all the different claim elements and you're going to have to prove that. So it's a little bit harder, but it's definitely an option as well. Yeah, so that's the note for if it's a product that we're talking about. So depending on what your business is, patent law might be the way to go, but you do have to get a patent first for that. All right, I guess that is the end of our presentation. So thanks everybody. Do we have anyone want to jump in with questions or comments?
Yeah, I'd say if anyone has another comment, feel free to go off mute and just ask Sabrina and Elizabeth directly too.
And we're happy that we have our emails up here. If you guys think of something or want to continue the conversation later, we're available in this online world, aren't we all? But we hope this will be helpful to you guys, and we will get these materials tomorrow so that you can kind of have them for reference, because we think this is a very important topic and we're happy to share it with everybody.
Well, and I think it's often a topic that, you know, can kind of, or something as you're running a business can sort of go off to the side as like the immediate fires are happening, but it's good to have those really proactive strategies and the things that you can kind of consistently be thinking about as you're running your company and building your brand.
Definitely. I mean, the cost of getting some of this IP to start, I mean, we know everyone is cost conscious, but the payoff is so much greater. To get a trademark registration, to have that in hand can be huge, and the cost can be pretty minimal compared to the risk if you don't get it.
Yep, absolutely. And it's very important to, even if just quarterly, you're sitting down and doing a quick Google search and sweep of infringing products or counterfeits or websites that might be using similar trademarks. That shows that you're taking an active step to protect and manage your trademarks, which will pay off dividends and huge in the future if you do run up against an infringer that is trying to kind of take over your brand.
We actually just got another question in the chat if you guys want to check it out.
So can you be sued by not registering the logo? It's not a matter of necessarily registering the logo or not registering the logo. At any time, you know, a a company that if they think that you're infringing on their trademark, they can take the steps that we've been talking about here to enforce their mark against you. It's the same kind of, on the one hand, you guys want to go out and enforce your marks and make sure that you're kind of clearing the legal pathway and the trademark pathway for your brand to be successful. The same side of that, other companies want to make sure that they're clearing the way for their brands and their trademarks. So with or without your registration, they could send you a cease and desist letter at any time if they determine, that it's too similar, it's too close. That being said, certainly having a registration on your logo, on your mark, will help you defend against that claim. So if you go to the trademark office and get a registration, they could come back and, as Elizabeth talked about before, cancel that registration, but it is certainly strong proof and stronger evidence that you have rights in your mark. So if you're just talking about yourself, getting your registration is a strong piece of evidence that says that you have definitive rights in your trademark. Does that make sense and kind of answer your question, Robin?
It feels like it's both a got to protect myself, but also be like out there strategy at the same time.
Yep, absolutely. It's both. Your trademark registrations are your shield and your sword. Do you need to file with both Colorado and federal? Your federal registration. So if you're operating only in Colorado and you only sell goods and services in Colorado, you will not be able to get a federal registration. So you would want to get a Colorado state registration. If you have customers that are from all over the country or even just a couple of various states throughout the country, get a federal registration, and then you're protected in all 50 states and you don't need that Colorado. If you have the federal, you don't need the Colorado. If you can't get the federal, absolutely go get a Colorado state registration.